Information Technology Act was passed in the year 2000 and came into effect on October 17th. We will see that what kind of structure the act has and what kind of provisions it has on implementing this particular act. Actually, if you look at the structure, you can see that there are 13 chapters spread over 19 sections with some schedules. Schedule is nothing but a list of the tables that has been given in the act. And the act begins with the preliminary and definitions, and from there on it moves on to the chapter and deal with the authentication of electronic signatures and digital signatures and other things. And there is a elaborate procedure has been given about certifying authorities who will be certifying the digital signature, and the elaborate procedure has been explained in that. And the civil offence of data theft, if there is somebody is taking over the data, then the civil offence of the data and the process of adjudication and appellate procedures have also been described in this particular chapters. The act goes on to define and describe some of the well known cyber crimes and lay down the punishment thereof. So, what are the possible areas in which crimes could be committed and what could be the procedure for awarding them or punishing them. So, this has been thoroughly explained in this particular act. We will see chapter by chapter. I will explain you something about very significant chapters. To start with, let us see what is chapter number 2. Chapter number 2 of Information Technology Act 2000 specifically stipulates that any subscriber may authenticate an electronic record by affixing his digital data called digital signature. It further states that any person can verify an electronic record by the use of public key of the subscriber. So, this has been elaborately discussed in the chapter number 2. We will see that what is being stipulated in the particular chapter called chapter 3. Chapter 3 talks about electronic governance or e-governance, what are the matters that is related to e-governance and what needs to be done, and those things have been clearly explained in the chapter 3. Chapter 3 talks about the electronic form, what is the electronic form and who can accessible the form and how to use that forms and how that references can be made, and chapter 3 also describes the legal recognition of digital signature, how the digital signature has been legally recognized and how this is being authenticated. And chapter 4, if you look at chapter 4, this talks about the scheme and regulation of certifying authorities. We saw that there are 4 agencies have been given with the NIC and TCS, they have been given with the authentication and certifying authorities. So, the act envisages that those agencies how to behave and how to deliver, and the controller, the act will appoint a controller, he or she will specify the various forms and content of digital signature. So, what will be there in the digital signature certificates, and the act accepts the need for recognizing foreign certifying authorities, and it further details the various provisions for the issuance of license to issue digital signature certificates. If we move on to the chapter 7, and this chapter 7 of the act details the scheme of things related to certification only. The act discusses the duties of subscribers are also enshrined in the act. What if you want to use digital signature, then what are the duties for you? How to be ethically and legally being accepting the terms given in the act has been clearly given in this particular chapter. If you move on to chapter 9, this talks about penalties and adjudication for various offences. All offences in the cyberspace is being discussed in chapter number 9. The penalties for damage to a computer system may go up to rupees 1 crore, that is what the system says, and the act talks about appointment of an officer not below the rank of director to the government of India or an equivalent officer of state government as an adjudicating officer to judge whether any person has made a contravention of any provision of the act. The officer has been given the powers of a civil court. So, how to punish somebody that who is committing crime in the civil space, in the cyber space, that is being defined in this particular act. Chapter 10, it talks about the establishment of cyber regulation appellate tribunal. So, when there is a issue, then how to appeal when you are not satisfying with the judgment of the director or whoever that who is being appointed to look into the matters, then you need to have an appellate authority. So, how to appoint an appellate tribunal who are the members, what are the regulations, that is being defined in chapter number 10. And chapter 11 talks about various offences which could be investigated only a police officer not below the rank of a DSP or Deputy Superintendent of Police. These offences include tampering with the computer source documents, publishing of information that is obscene in electronic form, and hacking. These are all the hacking, obscene publication and pornography, uploading, these are all the things that is being dealt at the level of a Deputy Superintendent of Police. And there will be an advisory committee to regulate the cyber space, that is called Cyber Regulations Advisory Committee. So, the Act provides for the constitution of Cyber Regulations Advisory Committee, which shall advise the government as regards any rules for any further purpose connected with the said Act. So, there will be somebody called the advisor, he or she will be advising the government to talk about this. And if you look at the schedules, there are 4 schedules. The Act also has 4 schedules which amended the Indian Penal Code. We saw that we have amended major acts like Penal Code and Evidences Act and Bank Act. So, these are all have been given in the schedule. The first schedule talks about Indian corrections or amendments in the Indian Penal Code 1860, and the next schedule talks about the Indian Evidence Act 1872, then the Bankers and Books Evidence Act 1891, Reserve Bank of Act 1934. So, all these things have been given in the schedule of the Information Technology Act 2000. If we move on to the salient features, why this act is more important? If you look at some of the sections are very important. So far we have seen that what are the chapters. Now we will go into the finer detail into the sections. Some of the sections are very important because they are very much relevant to the administration of the cyberspace. So, we will start with the section 1. It extends to the whole of India. Section 3, authentication of electronic records. Think about a world where everything was new, internet was new and authentication was new, digital signature was new, then everything has been clearly spelled out in section by section. So, section 3 talked about the electronic records in an authentication way. And if you look at further, legal recognition of electronic records, legal recognition of digital signature has been given in section 5, and retention of electronic records section 7, and publication of official gazette in electronic form, that is section 8, and security procedure for electronic records and digital signature section 14, 15 and 16, licensing and regulation of certifying authorities for issuing digital signature section 17 to 42, long sections, and functions of controller section 18, and controller to act as a repository of all digital signature certificates. Who will be controlling the entire digital signature certificate? There will be a controller, and how to act, what are the conditions, what are the functions of the controller, that is being provided in section 20. Protecting the data, right, that is a huge challenge that we have been facing now. So, data protection has been clearly spelled out in sections 43 to 65, and various types of computer crimes defined and stringent penalties provided under Act has been given in section 43, section 66, 67 and 72. And appointment of adjudicating officer for holding inquiries under the Act. Who will be the adjudicating officer and what are the terms to appoint some adjudicating officer, that has been specifically spelled out in section 46 and 47. Establishment of Cyber Appellate Tribunal Act, that has been given in section 48 to 56. Appeal from order of adjudicating officer to Cyber Appellate Tribunal and not to any civil court, that has been given in section 57. And appeal from order of Cyber Appellate to High Court. Who can go to the High Court? What are the conditions then? That kind of things have been explained in section 62. Interception of information from computer to computer. So, who can intercept? Interception of information from computer to computer has been clearly defined in section 69. And how the systems are protected, section 70 talks about it. And if you look at section 75, it talks about applying the offences or contraventions committed outside India. Whoever that who commits crime outside India, they can be booked under section 75. And who can conduct the investigations? That is section 79, that talks about investigation of computer crimes to be investigated by an officer not less than the rank of Deputy Superintendent of Police, and network service providers not to be liable in certain cases, and the power of police officers and other officers to enter into any public place, search and arrest warrant that can be issued with the section 80. So, the entire act is defining various sections like this, and offences in companies act, that has been how the companies are being booked under the offences, that has been defined in section 85, and the constitution of cyber regulations advisory committee who will advise the central government and the controller, that has been defined in section 88, and the Information Technology Amendment Act 2008. So, the act was passed in 2000, and over the 8 years we have been coming out with a lot of issues that has been needs to be addressed with a lot of amendments. So, there is a huge set of amendments that were introduced in Act Information Technology Act 2008. That was a major significant amendment that has been taking place. So, the IT 2008 Act Amendment Act was passed by two houses of Indian Parliament on December 23 and 24 of 2008 and came into effect on 27th October 2009. The Information Technology Amendment Act 2008 that has expanded the scope for the cyber crimes. The new form of cyber crimes have been added and the ambit has been improved upon. And the new and improved act aims at tightening procedures and safeguards for monitoring the interception of data to prevent cyber crimes. Now, let us see that what are the offences mentioned in the IT Act 2008, ranging from 65 it goes on to the end. So, section 65 talks about tampering with the computer source documents, what are the punishment and what kind of imprisonment that is being stipulated in this particular section. So, for committing the tampering of computer source documents, somebody will be punished for 3 years or with 2 lakh rupees or both. For section 66, it talks about hacking dishonestly or fraudulently, whatever that computer that is being hacking, then the Indian government will the judicial system will offer 3 years of imprisonment or 5 lakh rupees of fine or both. And for 66A, actually this section was deleted, struck down by Supreme Court. Even then you have to know that there was a section called 66A which punished people who sent offensive messages through communication services etc. They have been punished for about 3 years of imprisonment with a little fine. This actually was struck down by Supreme Court of India. And section 66B that talks about receiving stolen computer resource or communication device will be attracting a penalty of 3 years of imprisonment with or 1 lakh of rupees of fine. And section 66C talks about identity theft. If there is a theft of identity then through computers, then he or she will be fined with 3 years of imprisonment and 1 lakh of rupee. And 66D talks about cheating by impersonation by using computer resource, something called phishing. Phishing is the term that we already saw that is a term that is used in the banking. So, when somebody is involved in phishing, he or she will be levied with 3 years of imprisonment and 1 lakh rupee. And section 66E talks about violating privacy or video voyeurism. In that case, it fined with 3 years of imprisonment and 2 lakh of rupees. Particularly when somebody is involved in cyber terrorism, then 66F will be revoked and people will be given lifetime imprisonment. Actually, cyber terrorism is the worst form of offence that is being spelt out in the particular act. And if you look at 67, it talks about obscene material publication. If somebody using the internet or cyberspace to publish offensive material, something like obscene material, then he or she will be fined with 3 years of imprisonment and 5 lakh rupees. And 66(7)(a) talks about transmission of sexually explicit material or act of material, then he or she will be fined with 5 years and 10 lakh rupees or 7 years and 10 lakh rupees. And particularly somebody is involved in child pornography, then 67B will be used, that tries to punish people up to 5 years and 10 lakh rupees or 7 years up to 10 lakh rupees. And the last section here is 67C that talks about intermediaries who involved in that, they will be punished with 3 years of imprisonment. In this part of the presentation on Information Technology Act 2000, we discussed about the structure of the act in detail, particularly about the chapters, the sections, the schedules, and then we moved on to discuss about the salient features of this particular act, and we concluded with the offences that has been listed in the Information Technology Amendment Act 2008. In this presentation on Information Technology Act 2000, we discuss about the context in which the act was introduced, starting from the UN role, how the United Nations introduced the model law and how that was taken by NASCOM and how that was introduced in Indian Parliament. So, it was how this has been introduced in as an act in the Indian subcontinent during the year 2000. Then we moved on to understand that what are the objectives, what are the major aims of this particular act. Then we moved on to try to understand the structure of this act and then functions of this act, and then we moved on to understand what are the major offences that is being considered as an offence under this particular act. Hope this particular presentation would have given you a comprehensive idea about Information Technology Act 2000. Thank you for watching.